Alright, can you hear me now? Alright. Now that I just wasted 5 minutes of my time, I'll go back over to rehash this. Okay, there's four documents filed today on the 24th. This is just them stating that plaintiff has requested that they turn over all documents that they have. And this is just a rehash of the last filing we had, which if you watch my last video, that has to do with the Colborn case. It goes over everything. Basically, they had a private investigator and attorney submit documents stating that they want all the information. I do not want to read all this over again, but I will. Now comes Andrew Colborn by through his attorneys, law firm Conway, C. Jerry, and I hereby request the defendants respond to in writing under oath the following written interrogation request of production of documents within 30 days, time served made upon herewith accordance with Wisconsin statute. Andrew Colborn by through his attorneys hereby further requests pursuant to Wisconsin statute 80409 that you produce all documents, reports, records, other similar related materials referenced below, which either in possession readily available to you. These documents, reports, records, similar related materials shall be produced at offices, law firm Conway, C. Jerry, by 30 days. This is just basically instructions on what they're requesting. Why they're requesting all of it? Good question. Plaintiff by through his undersigned counsel hereby respectfully moves that the court for sanctions against defendant Netflix pursuant to the court's inherent authority for the reasons set forth and explained further in the supporting memorandum filed contemporaneously and further based on the facts set forth the declarations by Deborah L. Bursick, April Roxy Baker, also filed contemporaneously. Plaintiff request the court in order Netflix Incorporated contesting actual malice in these proceedings or such sanction in court may be appropriate during circumstances. So I spoke with Leah Walker, counsel of Netflix, Kevin Vick, counsel of Crow Media, Laura Riccardi, Maura Demos, in good faith effort to resolve, limit, or streamline discovery issues in dispute on September 16, 2021 by telephone. In my understanding, based on the conversation with Netflix, has adopted an instance of the ACI protocol, which is required before discovery could be produced by it. But it maintains that it will produce a discovery response to plaintiff's June 2020 request, which were intended to request documents described in Netflix June 2020 initial disclosures on a rolling basis, likely to take until mid-October. In the meantime, Netflix has served discovery requests after asking for information, the details of which they are likely to be disclosed, and the discovery served on it. It is understanding that Netflix will consider requests for extension of the responses for specifically articulated reasons, but the Netflix will not agree to extensions based on which own discovery delays or until concludes in its production. Based on the totality of the circumstances, including the lack of any further document production, since a few documents were produced the day after September 16th, 2021, meet and for a conference based on the pattern of delay, denial, discovery, the plaintiff counsel has been met with during the time the case is pending, which is now more than 2 years and nearly 3 years. And based on the email message sent by Netflix after the meeting and confer that characterizes Netflix past conduct with respect to discovery of appropriate, it is unfortunately apparent to the plaintiff's counsel that Netflix is not willing to acknowledge that it has and continues to unreasonably delay plaintiff's access to discovery in a way that appears to intend prejudice plaintiff in these proceedings, particularly with respect to the defendant's impending motion summary judgment. So basically, Andrew Colborn is asking for whatever they have because he doesn't have anything. And this is a 30-page document. This is the last document, declaration. As a court where plaintiff Andrew Colborn filed his defamation against the defendants Netflix Incorporated, Crow Media, Maura Demos, Laura Riccardi to obtain redress to damage to reputation arising in the defendant's motion making a murder broadcast. As plaintiff's second amendment complaint explains, defendant falsely stated with audience that the plaintiff's prior employment as a law enforcement officer, he framed an innocent man who is now in jail for a murder. Plaintiff has been attempting to obtain document discovery from the defendant since nearly the inception of this case, To date, nearly 3 years later, a small fraction of the requested documents produced late last week, only when it became apparent through meet and confer requests that the motion imminent. Defendants still have not produced the majority of the responsive documents, including most significantly communications between Netflix and the Crow Media defendants relating to the production and broadcast that is issued in this case. Under governing law, and further explained below, sanctions are appropriate, although most served sanction default would be supportable based on this record. Plaintiff requests that as a minimum the court enter an order bearing Netflix consistent actual malice for the purpose of proceedings in order bring a swift conclusion to the procedural gamership surrounding this issue and allow the remainder of the case proceed trial expeditiously. Procedural history. Plaintiffs served the first set of discovery requests on Netflix with the state court pleading in early 2019. Direction of Deborah Ebrus, 2-3 Exhibit 1. The first set of requests were comprehensive and responsive would have permitted plaintiff to properly analyze and evaluate pertinent materials in Netflix possession, interrogatories, and document requests. Defendants subsequently removed the action to federal court and filed 2 separate motions to dismiss. Netflix motion to dismiss was denied after a hearing in December 2019. The court also granted plaintiff leave to file a second amended complaint. Netflix filed a second motion to dismiss early 2020, docket 120. After reviewing Netflix's second motion to dismiss in an effort to serve requests tailored specifically to the materials plaintiff belief with the implicated by Netflix motion arguments, plaintiff served second set of documents requested in Netflix that specifically targeted the raw footage of the plaintiff that was killed for the Making a Murder series. In cover letter, plaintiff's counsel stated, "We are in receipt of the memorandum in support of Netflix Incorporated's motion to dismiss plaintiff's second amended complaint. With the body of her memorandum declaration to Matthew Kelly, Netflix produced considerable amounts of evidence that previously in record and beyond our pleadings and allegations to complaint. To date, no discovery has been produced, as I previously discussed by telephone with James and Lydia. We do not see any reason the discovery should not be proceed at this point, particularly in any pending motions likely will not decide for many additional months. We are therefore requesting that you advise when you are available for Rule 26 conference as soon as possible. We are enclosing additional discovery requests that pertain to this issue raised by the defendants. We are also requesting the answer first set of discovery, which is outstanding for nearly a year, within 30 days. In late March 2020, Netflix counsel discussed statute of discovery in a telephone conference with plaintiff's counsel. In the conversation, Netflix counsel indicated that even if they wanted to produce the material requested in the second set of document requests, they could not do so because due to the pandemic, too many people were under lockdown and were sheltering in place in California. The parties therefore preserved for the time being their dispute regarding Netflix's assertion that it should not have to produce the requested discovery until its second motion to dismiss is decided. Netflix counsel did not suggest at the time that Netflix did not have access to the materials other than due to the pandemic. Together with this response to Netflix's second motion to dismiss, plaintiff's counsel filed an expedition motion requesting the defendants be required to participate in Rule 26. So basically, Andrew Colborn ain't got shit to prove his case yet. It's all based on speculation. My take on things. Participant in Rule 26 conference light defendants continue refusing to do so. The next day, without awaiting a response, the Honorable Pamela Pepper, then presiding in this case, entered an order requiring the parties to submit to a joint discovery plan within 30 days. In this joint discovery plan, the parties therefore submitted defendants described their position. They should not have to produce any discovery until the motions to dismiss filed for respective defendants were decided. 3 months later, in early September 2020, plaintiff's counsel sent an email message to defendants' counsel requesting further clarification regarding purported unavailability to the materials responsive to the second set of documents requested. Barker, Exhibit 2, the message stated in presented part. We are writing to revisit the issue of our request production, at a minimum, the raw footage. For those reasons explained, pages 65-66 of our brief response to the most recent motion to dismiss. While they were there to take the possession of the most germane to the issue presented by the motion, we disagree. Moreover, we are aware that no rule that categorically bars discovery at a point in this case. Recently, the following article was brought to my attention. If you guys want to look up this blog, it's on the internet, Netflix, techblog.com. It asserts, among other things, Netflix adopted Google Cloud's G Suite in 2013. This means that our entire corporate file sharing platform is in Google Drive. Thousands of users, millions of files within the cloud, accessible everywhere. Given the likelihood, according to this article, that the information we seek is electronically available to any number of Netflix representatives and is likely accessible from anywhere, it appears that we may have been duped into this understanding that the material cannot be safely produced during the pandemic. They're assuming things. It also has been brought to my attention that Netflix, like many other television and movie producers, is poised to resume filming in September on some productions despite conditions of the pandemic. Accordingly, even assuming that the raw footage is not readily available through electronic filing sharing, it appears unlikely that the current conditions would prevent all access to the areas in which the materials are stored. I also note that I have received 4 separate document productions in other cases just in the past several weeks. Therefore, other firms are finding ways to produce documents in a timely manner. We appreciate the candid response to whether the raw footage is technology accessible and regarding its availability. If we cannot secure some basic cooperation in obtaining access to the material so that we can determine whether any of it may warrant a supplemental response to the pending motion to dismiss at this merits, then in the interest of advocating of our client's interest, we all have proceeded to file a motion to compel after requesting a telephonic meet and conference session to discuss this issue. After waiting 25 days, Plaintiff's counsel again wrote Netflix counsel to follow up on the request. Baker Dell Exhibit 4, Netflix counsel responded to the motion in email message the next day, stating that while she would be willing to talk, she was not sure there is much to gain from a phone call because she had confirmed since you emailed earlier this month that Netflix does not possess and had never possessed the raw footage you seek. Netflix counsel also indicated that because Netflix continued to oppose any discovery prior to the resolution of its second motion to dismiss, there was a fundamental disagreement between the parties about how and when discovery should proceed. Netflix counsel further suggested Netflix was taking Judge Pepper's failure to contact the parties after filing joint discovery plan as a sign that the court agreed the defendants could refuse provided discovery until the motions to dismiss were decided. After a meet and confer conference, plaintiff filed a motion for an order compelling initial disclosures. At a December 2020 conference with the court that occurred after judicial reassignment, the court indicated that the defendants did not have license to grant themselves unilateral self-imposed stay of discovery and noted that the defendants should have sought protective order. At audio attachment 3520 into proceedings, the court ordered defendants to answer any pending or outstanding discovery within 14 days of the court determination of the pending motion is dismissed. Nothing to do with the circumstances, procedurally, morass. Waiting resolution due to the various motions to dismiss, the court required defendants to turn around response promptly after resolution of the motions. After the court decision denying the defendants' motions, Netflix provided a written response to plaintiff's second set of documents requested, but not the first set. Netflix takes the position that plaintiff's first set of discovery is moot as a result of the removal of the federal court. It also became apparent after this fact that Netflix was ignoring the express request in plaintiff's counsel's March 2020 letter that the defendant's answer to the first set of discovery requests on the ground letter did not include any copy of the request. In response to plaintiff's second set of document requests, Netflix asserted numerous objections before reiterating there allegedly does not have possession of responsive materials. In November 2020, a response in an identical set of documents requested that were also served on Chrome Media defendants. They likewise asserted numerous objections that leave a reader uncertain as to whether they claim to have none or only portions of the raw footage, and whether they are withholding any of it or all due to solely their objections. With respect to the defendants, court ordered initial disclosures, which would occur within 14 days of this decision, and in motions to dismiss. The rules provided that the defendant may provide a copy or a description of category and location for the document's materials. Unsupervised defendants uniformly elected to describe rather than produce. Barker DeSalle, when the plaintiff's counsel made a follow-up request for access to materials requested in an initial disclosure, Netflix counsel responded that the materials would be made available in response to a formal request after entry of the protective order. Plaintiff sent a formal request following day that mirrored the language of Netflix's initial disclosure. Plaintiff's counsel also requested that a proposed protection order be forwarded as soon as possible, and an order facilitated that exchange of documents. A week later, counsel for the Chrome Media defendants filed. Do you think they would put dates on all these things? Counsel Chrome Media defendants filed the proposal protection order to plaintiff's counsel, indicating that it was drafted to closely follow the model protective order contained in Eastern District of Wisconsin local rules. Netflix subsequently responded with a written response to the third set of discovery requests, indicating that it was produced responsive documents subject to numerous objections and to the protective order. Communications between the counsel and revisions of the draft stipulation for the protective order were made in light of court's comments July 28, 21. Status conference, the court signed protective order August 19, 2021. Plaintiff's counsel again asked defendants' counsel on August 23rd that they would provide documents to access them. Netflix counsel advised they would be forwarding a proposed electronic discovery protocol that would address such things as Bates numbering, production format. However, when the document was received 3 days later, plaintiff's counsel found that it purported to impose numerous technical specifications to both parties. The discovery request and contained a provision which exempt Netflix from searching for or producing documents that is deemed not available and usable for ordinary course of business. Proposed stipulation and order. After reviewing the proposed protocol, plaintiff's counsel wrote back to Netflix counsel stating in pertinent part. In initial joint discovery plan, the party advised the court as follows. Any issues concerning discovery, disclosure, discovery, or preservation of electronic stored information, including the form in which it should be produced. At this time, the parties did not anticipate any special issues related to the disclosure of discovery or electronic information, but will probably address many issues that are arising during the course of discovery. When defendants insisted that the updated joint discovery plan provided prior to the most recent scheduling conference, the foregoing assertion was reaffirmed by reference. According, we request that the producer response documents within a week of the communication of the producer is specified in pertinent federal rule. Producing documents electronically stored. This is just like going over the other document, just stipulating what is what and what it means. The counsel of the parties met in conference on December 16, 2021. Netflix counsel indicated that Netflix would now make a document available without waiting the ESI protocol. Through Netflix still sought agreement to protocol prior to the production by plaintiff. Counsel indicated that some documents would be produced shortly thereafter, and that Netflix anticipated providing remaining responsive documents by mid-October. According to Netflix's characterization of the foregoing procedural history, Netflix has worked diligently to collect and review documents, made meaningful progress towards production, and plaintiff appraised its progress. Day after the meet in confer call, Netflix produced 7 documents, but not the bulk of responsive materials. No further documents have been produced as part of the rolling production to date. The memorandum submitted support of the plaintiff's request order for sanctions against Netflix's ongoing efforts to obstruct progress in the case and to delay any deny access to information. Tactics have kept plaintiffs in the dark, and like the eve of the motions for summary judgment, defendants have indicated they intend to file docket 184 part 2. We just went over those first. In evident preparation of the motion, Netflix counsel has served interrogatories, and plaintiff purport to require plaintiffs to essentially distinct Netflix role in the production of each statement in the broadcast. Hold on, I got messages here that I don't know why they're being hidden. No, they were deleted. Never mind. Kept plaintiff likely motion. Defendant of preparation motion. Counsel have served interrogatories on plaintiff. Purport the plaintiff's essential dissect the Netflix role in production of each statement broadcast that is issued in this case. Interrogatory number 2, document requested. At time, defendants have yet to provide a good faith response to majority plaintiff. Argument: sanctions are appropriate for defendants' extended discovery, delays, and obstruction. The history of plaintiff's attempt to obtain discovery from defendants is likely lengthy, but it is simply to understand what has been happening. The defendants. Where was I? Defendants' third motion, summary judgment. Dilatory tactics, cumulative in the production and failure to produce discovery, thwart and undermine the judicial process, delay progress in the case, waste the courts and parties and their counsel's time. Therefore, severe sanctions may be imposed. The court can issue sanctions under inherent authority, including severe sanctions such as dismissal and default, to penalize discouraged misconduct. When the party engages in abusive and obstructive discovery tactics by failing to properly respond, the court may impose sanctions. Recourse to sanctions is appropriate even when there is not prior order, because the federal discovery rules gave ample notice to litigants regarding how properly conduct themselves. An discovery disclosure system designed to operate insofar as possible without a judicial intervention. Insurance of the court order in the first instance is unnecessary before sanctions can be issued. Similarly, under Rule 37, Federal Court Rules of Civil Procedure, sanctions for failure to comply with the discovery order include the desertion to deem the facts established, bar evidence, strike dismissal pleadings, enter default judgment, and find party in contempt. Proportional discovery failure. Default judgment proportional when willful bad faith violations of discovery orders and pardon of the commutaneous conduct of dilatory tactics where conduct falls outside the expressed terms, but evidences pattern of abusive and bad faith litigation practices. It can be remained by through court's inherent powers, Johnson statutes, blah 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 blah. Sanctions are not intended merely to punish specific conduct. They also serve the important purposes of determining those who might be tempted to such conduct, absence of such deterrent. Therefore, a court now need to fire a warning shot by imposing sanctions less drastic than dismissal or default judgment where there is a clear record of delay or circumstances conduct. In Altepex Supra, a district judge in the circuit court adopted a magistrate's recommendation to impose severe sanctions dismissal when a party produces some, but not all, documents. Several months after the first request of those documents led to the opposing party's counsel what amounted to a wild goose chase for the remaining documents, spanning more than 3 years. The court issued a severe sanction dismissal based on a sequence of events and suggested a willful pattern of disagreed for the court's orders and rules. Similarly, in Houston case, the Seventh Circuit upheld sanctions that district court imposed against the defendants who conducted, impelled, delayed, and frustrated the plaintiff's efforts to obtain discovery. The court explained that there was ample evidence the defendant had acted in bad faith, knowing that even though the party had been alerted to the need to search for secure documents, the receipt of a non-party subpoena that he had been served on prior to the time it was added to the defendant, It did not conduct an initial search prior to discovery obligations until the 4 months after it was added to the case. In addition, the defendant failed to provide information concerning important issues in the case in a timely manner, and failed to alert the plaintiff that could not provide some of the information. In the case, court ordered defendants produce any outstanding pending discovery within 14 days after the decision. Motion is dismissed. The court issued a decision May 26, 2021. Since that time, defendants have complied the letter only to the court order. They have clung to hyper-technology formalities, such as by contending that they utterly ignore plaintiff's initial set of discovery requests, despite a specific request following removal that they be answered. Barker, the Exhibit 1 defendants, further played a shell game with the raw footage of the Avery trial that was requested in the second set of discovery requests, either apparently contending that none of them or they have consecutively failed to produce it. With respect to the initial disclosures, they were also provided within a 14-day window. The court decision, Netflix forced a formal request for its documents and failed to timely produce them. First insisting that the production be delayed pending a protective order that could have been negotiated long prior to giving the Myers local rules standard order. Then, after entry of protective order purporting a production on further modifications of defendant discovery obligations, most recently, Netflix counsel has claimed that it has been working diligently to identify and collect documents as purported to describe in its initial disclosure that were formally requested 3 months ago. In the time since plaintiffs served discovery requests to obtain documents described in the defendant's initial disclosures, it is difficult to understand how responsive materials could not have been assembled as substantial part. During the time the parties were discussing protective order, defendants effectively obtained additional time for themselves to prepare at least the bulk of response documents after already operating under a self-declared stay of discovery in toto during the time that their serial motions to dismiss were pending. In light of their circumstances, a claim need for additional time procedure documents middle of the next month rings hollow. Based on his history of this case, plaintiff is likely only to be further prejudiced if he now takes the face value of Netflix's 11th hour suggestion that all the responsive documents will eventually be forthcoming. After immensely successful and repeated rounds of keep away, it is immensely foreseeable that the defendants will move on to blind man's bluff, moving on for summary judgment in a vacuum that has been carefully orchestrated by the defendants. Discovery rules are intended to ensure that civil court proceedings are less a game of blind man's bluff and more of a fair contest with the basic issues, facts disclosed, fullest participable extent. The federal rules disfavor summary judgment by ambush, just as they disfavor trial ambush. Defendants pattern a non-cooperation delay in arguing themselves the conditions under which they will respond to any discovery collectively, response in a format expective of the good faith cooperation that underlies the federal discovery rules. Plaintiff respectfully submits that order bearing Netflix from contesting actual malice for purposes of these proceedings will be appropriate sanction for the pattern of delay, obstruction, evidence in response to plaintiff discovery efforts in this case. It will also prevent Netflix from benefiting from its own tactics of thwarting and delaying discovery regarding the very issue in which it intends to move summary judgment. Due to lengthy delays in proceeding these documents, plaintiff has not had an opportunity to take part or witness depositions to obtain testimony that can be presented to the court in opposition and impeding motions. Under the principle of fool me once, shame on you, fool me twice, shame on me. Dude, what is up with all these courts and these stupid analogies and dumbass sayings? I don't understand it. Plaintiff anticipates that they will be put in an even worse position if he awaits now belatedly promised production month from now, only to determine that more likely a less than complete production necessitates further meet and confer discussions, motion practice, and delay. And all while Netflix likely insists on pushing forward with the motion for summary judgment. Sanctions are appropriate under the court's inherent authority based on the apparent or willfully delay obstruction, light of defendants, including the spirit is not a letter of. Little footnote, In addition, for reasons for plaintiff intends further explain the supplemental memorandum, which requires filing materials produced under a protective order under seal. Netflix first motion dismissed based on the issue actual malice appears in retrospect to mean based on an assumption of the motion would be granted without ever affording plaintiff opportunity to examine materials relevant for a factual association made. The subboard of Netflix agreement and amendment would be futile under the circumstances of the case. The court's December 2020 order, which was intended to ensure defendants produce discovery promptly after the court's decision, blah blah, and the motion is dismissed. Conclusion: under federal rules, discovery should not be capsule as experienced, and if it was made into one, there would be appropriate consequences for the reasons set forth above. Plaintiffs respectfully request that the court enter an order barring Netflix from contesting actual malice for purposes of these proceedings. Yeah. And then this is the court. I'm not going to read all this. This is, if you want to, you can look up the case right here. Basically, it's everything that they listed. And that's why it was 30 pages and only 15 pages. I don't know, I want to read all this. This is just basically the two court cases that they cited why Netflix should turn over everything. But yeah, it seems like Andrew Colborn doesn't really have a case. So, I don't know. Should be hearing something soon, so I guess you guys have a good day. And I'm sorry about the hiccup with my audio in the beginning, but take care.